Welcome once again to Lehto's Law. Here's Steve Lehto.
Robert sent me a note. It says, Steve, check it out. The Utah Supreme Court on the cutting edge of legal jurisprudence being asked to answer a question that many people have asked. And they are asked to decide if cell phone passcodes are constitutionally protected. Fox13now.com runs the story, written by Ben Winslow. And the Fifth Amendment is what we're talking about here. So let's assume there's a situation where you engage with law enforcement and they grab your cell phone and they go, give us the password to your cell phone. So we want to get into it and poke around. You go, no. Actually, you remain silent. Don't even say no. So they get a warrant. They go get a warrant. Come back with a warrant. They go, here, we got a warrant. Now give us the password. Still refuse. What can they do if you refuse, even in the face of a warrant, to give them the password to your phone? So the state's top court will decide if cell phone passcodes are protected under the Fifth Amendment right against self-incrimination. And remember that the Fifth Amendment contains a whole bunch of things and says that no person, blah, 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 blah. And then, nor shall be compelled to be a witness against himself. Nor shall be compelled, and I'm leaving out a thing that says, in a trial, nor shall be compelled to be a witness against himself. So if they say, give us your password, are you then being a witness against yourself? And most of the time, people reduce this to your right to remain silent. But that's not exactly what it says. It says your right to not be compelled to be a witness against yourself. But are you a witness against yourself giving up the password? And that's the issue. So recently, the Utah Supreme Court heard arguments in a case involving a man who was convicted after trial for a whole plethora of things, and police had sought a warrant for his cell phone as part of their case. He refused to give them the passcode for the phone's lock screen. He refused, didn't care. At trial, prosecutors argued to a jury that his refusal to give up the passcode implied he was guilty. And I've talked before about the idea of spoliation of evidence. That is that if there's evidence that you destroy before trial, the other side can say they destroyed it because it made them look bad. And the judge will inform the jury of that. Now, this is a little different. But this is the kind of behavior where somebody can say, based on how they behaved, we can figure some things out about them. So another example of this is if you run away. So let's suppose that the police show up at a scene where something has happened and you bolt, you run away. And they chase you down and grab you, okay? They can, quite often, argue in court that you ran away because you'd done something wrong. You don't run away if you did nothing wrong. Now, I know some people in the audience are going to say, Steve, some people will run away just because they don't want to get something hung on them that they didn't do. That's fine. You can make that argument to the jury also. But they can often make the argument that says a person who's fleeing the scene of a crime is often doing so because they are somehow linked to it and guilty of something. So at trial, prosecutors argued to the jury that his refusal to give up the passcode implied he was guilty. Now, the Utah Court of Appeals reversed that and sided with the man, saying the passcode was protected under the Fifth Amendment. Again, the prohibition where you do not have to be a witness against yourself. The Utah Attorney General's office appealed that ruling to their Supreme Court, the Utah Supreme Court. Justices peppered lawyers for both sides with questions about historic constitutional rights and new technologies. And just recently we talked about cars and the fact that cars today contain data about you they didn't contain back in 1925. So one justice said, I guess we have two different issues here. Whether compelling the defendant to give the passcode is a violation of the Fifth Amendment, and if then, what remedy is available to the state if he refuses? An assistant solicitor for the state argued that this was no different than a signature or a key, things that can be compelled under a search warrant. And so apparently, if they say, we need you to sign your name right here, and you refuse, if they get a warrant, they can make you sign your name. But of course, that leads you to the question, what do they refuse? I mean, there's a pen right here, okay? And if I wanted to, I can just say no. You can hold the warrant in front of my face, I can still say no. Then what happens? That's the question. What's the remedy if the person refuses? So there are probably plenty of cases where the state knows the defendant is guilty, the evidence is overwhelming, but the defendant never says, I did it. He still has a Fifth Amendment right to not say, I did it. That's the Chief Justice questioning whether or not you can compel someone to do something like that. And he also says that, it's the Chief Justice again, says that the password is in your mind. You're thinking it. We can't compel you to tell us what you're thinking. We can do all kinds of things to encourage you or discourage you from not telling us. But obviously, a person can, if they want to, sit there with their mouth closed and refuse to talk. And people have done that. And quite often the remedy is contempt of court, to lock somebody up. That's the question, is what else could you do? So across the nation, court rulings have been mixed on facial recognition and fingerprints to unlock cell phones. So they get a court order, a warrant that says they can use your thumbprint. They could physically grab your hand and press the thumb up against the thing to get your thumbprint, okay? So they could do that, although that still seems a little unseemly. But the Utah Attorney General's office appeared to want a ruling on the use of touch entry passwords. We have a new series of cases here, and the concept should fit not just with the history of the Fifth Amendment, but should also take into account the realities of what's going on and the realities of encryption. That's the Assistant Solicitor General, John Nielsen, speaking to the court. Meanwhile, the attorney for the defendant at the beginning of this case argued that a person cannot be compelled to participate in their own prosecution. And so again, that's a rewording of the phrase, compelled to be a witness against himself. And she said, you cannot compel them to participate in their own prosecution. And I think that is a fair restatement of the sentence that comes from the Fifth Amendment. So the general idea, as most people understand it, is that if they charge you with a crime, from the moment you're charged, you have the right to go silent. You can sit there like a bump on a log, as they say, and you get to watch your trial and you get to participate in it. You could hire an attorney to cross-examine witnesses and so on, but you can sit there and literally do nothing but be a spectator at your own trial. And I think most people agree with that. So the only real question comes down to, can they force you to do anything beyond just sitting there and watching like a spectator? So she says that a person cannot be compelled to participate in their own prosecution. This case is about the state improperly commenting on his refusal to communicate his phone passcode when he was asked to do so by the police. In that sense, this isn't a new frontier or a new technology issue. This is simply a matter of, can they compel him to give up information that is in his head? His case has drawn support from the ACLU, the Electronic Frontier Foundation. The civil liberties groups submitted a friend of the court brief urging the Utah Supreme Court to side with the defendant. The ACLU wrote, the Fifth Amendment doesn't mean much if when we exercise that right, the state is then able to turn around and argue that us exercising that right should be used to imply guilt. And you should know, by the way, that in the old days, I'm talking about a long, long time ago, when a defendant took the Fifth and refused to testify, prosecutors were allowed to tell the jury, by the way, we put in all this evidence to show that he did it. He could have gotten up on the stand and denied that he did it, but he didn't do that. Why didn't he do that? And they could make the same argument about a person running from the scene as about someone not testifying. They could actually say that. The guy didn't testify. And they actually had nicknames for that, and some of them would be how many steps it was from here to there. The 3-step prosecution, the 10-step prosecution. They say, literally, he could have taken 10 steps to the box here, testified, told you what happened, but he didn't. And the Supreme Court said that's not right. Now, part of the reason, this whole point about nor shall be compelled to be a witness against himself wouldn't make sense if people could draw conclusions from that. So one of the jury instructions you'll hear if you ever sit on a criminal trial is the jury instruction that says the defendant does not have to participate in any way, shape, or form in this case, and you cannot draw any conclusions from whether they do or not. And it's worded differently in every court, so don't worry about that. The point is that the jury is specifically told that the defendant does not have to participate, and they get to sit there and do nothing, and you cannot make any conclusions or inferences from that. And by the way, the prosecution cannot argue it either to the jury. If they do, it is an automatic mistrial. Automatic. So the case has drawn support, like I said, from all those people. ACLU wrote the last statement about the Fifth Amendment doesn't mean much. The justices took the case under advisement, which they will often do. Cases decided by the Utah Supreme Court often have broader implications. So whatever the high court decides will impact other cases across the state and how law enforcement behaves going forward. Meanwhile, the man's attorney says, we need to draw firm, bright lines around our privacy and around our Fifth Amendment rights. The more the state is allowed to chip away at our privacy and chip away at our Fifth Amendment rights, that will have big implications moving forward for all of us. So, interesting case out of Utah. And I've seen this pop up in other places. We've heard this story before. I remember hearing a case about it where someone was simply crossing the border, coming back into the country. And they're an American citizen coming back into America, and they're stopped at the border. And the people at the border say, you've got a laptop, fire it up and type in the password. We need to take a look at that. And fights have ensued over that as well. So I'm not going to go there today. I'm simply talking about Utah and a defendant who was asked, can you unlock your phone for us? And he said, no. And so they then argued to the jury that that was an indication of guilt. And Court of Appeals says, no, it wasn't. And the Utah Supreme Court is now going to rule on it. So Robert, thanks for sending it from fox13now.com. Ben Winslow wrote it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I like to talk about dryer lint and coasters, the expansion of the universe, and maybe McDonald's. I'm completely turned off by the idea of politics.